of the Bar Council's Criminal Law Committee and Human Rights Committee. Thank you for joining us, Amer. And secondly, Professor Wong Chin Huat. And again, Professor Wong is no stranger to all of us. He is a political scientist who comments regularly on political and social issues in Malaysia. He trained as a comparativist in University of Essex, the UK, and specializes in electoral system and party system. Chin Huat is a long-term advocate for electoral reform in Malaysia through Bersih, and he has led clusters on electoral system and constituency delimitation in the Malaysian government's Electoral Reform Committee that was formed after the 2018 elections. Beyond political institutions, Chin Huat also studies identity politics and leads an annual survey on Malay Muslims in Malaysia, Nadi Melayu Muslim, funded by Germany's Friedrich Ebert Stiftung Foundation. Professor Wong's political insights are featured in international and domestic media in English, Chinese, and in Malay. And finally, Datuk Seri Panglima Wilfred Madius Tangau, who is the Member of Parliament for Tuaran in Sabah. He is also the current president of APCO. Now, prior to his political life, YB Madius was instrumental in various think tanks. He was the CEO of the Institute for Indigenous Economic Progress Sabah, where he advocated for the voices of the indigenous community in policymaking. YB Madius was elected to the Parliament of Malaysia in 1994 at the tender age of 36 for the Tuaran seat. He was appointed as chairman for several board and companies such as Sabah Cultural Board, Forest Plantation Development Sendirian Berhad, Malaysian Timber Industrial Board, and ASEAN Supply Sendirian Berhad. From 2015 to 2018, YB Madius was the Minister of Science, Technology and Innovation. He is active in politics and is a strong voice on certain institutional and parliamentary reforms, such as shadow cabinets. So thank you to all the panelists. Now, in terms of how we will structure today's session, each speaker, each panelist will be given the first 10 minutes to talk about the main issues relating to our topic today. So first up will be Amer, and Amer will briefly explain the decision in the case of Dewan Undangan Negeri Kelantan versus Nordin Salleh. Now, that is the principal case upon which our understanding of the state's authority to enact its own legislation is based. So Amer will describe how the decision in that case impacts the current efforts to frame and enact anti-hopping laws in Malaysia. Over to you, Amer. Sorry, we've got the wrong slides up, I believe.
Okay, good afternoon, ladies and gentlemen. First and foremost, I would like to extend my deepest gratitude to the organizing committee, the council, for having me. Okay. Okay, yeah, so I would like to express my deepest gratitude to Bersih Bar Council for having me as one of the panelists. And I would like to extend A very warm welcome to all the participants. And of course, to our esteemed panel speakers, I'm very honored to be among one of them. Now, the topic that we're discussing today is a very interesting topic. It's a very hot topic that's been debated, discussed either on proper forum or even at the kopitiam as to whether or not we should have anti-hopping law. I think that is no longer a strange topic even among those who are not aware of the legal position or what anti-hopping law is all about. Because of the recent changes in our political scenario, this issue is becoming something which is widely known to the public. Now, in discussing anti-hopping law, one cannot avoid from discussing or looking into one of the most prominent cases in our legal jurisprudence that deal with this very topic, which is the case of Dewan Undangan Negeri Kelantan against Nordin Salleh and another. This is a very famous case, a decision by our then Supreme Court that decides on the constitutionality of the Kelantan enactment that regulates or imposes a certain disqualification in the state constitution, whether a member of the State Legislative Assembly will lose his qualification upon jumping, or resigning from a particular political party and joining another different political party. And of course, the issue of freedom of association is one of the reasons given by the Supreme Court in that case. Now, before going into Nordin Salleh in greater detail, I would like to also highlight that apart from the case of Dewan Undangan Negeri Kelantan or the case of Nordin Salleh, there is also another case which was decided by the Supreme Court, but of course by a single judge sitting in a leave application. The case is the case of Abdul Karim bin Abdul Ghani against Legislative Assembly of Sabah, 1988, 1 MLJ 171. So if we look at the dates of these two decisions, it is very clear that the case of Abdul Karim bin Abdul Ghani was decided much earlier before the case of Nordin Salleh. And one of the issues that we will be discussing later on is which of the two decisions should we favor. Now, interestingly, in the case of Nordin Salleh, there was no reference made to this case of Abdul Karim, which is also a decision by the Supreme Court. Okay, now, coming to Nordin Salleh, let's understand the rationale or the reason given by the Supreme Court in holding that the enactment or the amendment that was made by the Kelantan State Legislative Assembly to restrict or to disqualify a certain member from being a member the moment one decides to leave a particular political party and join another political party. Now, if I can invite all of you to have a look at, okay. Now let's look at the decision of the Supreme Court. Now, if we look at this particular excerpt, now this is essentially what the Supreme Court had decided. They adopted the High Court decision. At the bottom in time, the High Court who decided the case was Justice Yusof Chin, our former Lord President as well. Now, in deciding that particular amendment to be unconstitutional, the High Court, in the case of Nordin Salleh, had referred to an Indian decision. They referred to the case of Mian Bashir, as can be seen there, Mian Bashir. Now, interestingly, in Mian Bashir, the Supreme Court of India was split. So there was a majority decision and a minority decision. Now, even though it is a majority and minority, but in terms of the composition of the judges, it's actually 2 and 2. But because the acting CJ was in the majority, and because of the law in India saying that therefore the decision of the acting CJ forms the majority decision. Now, In Malaysia, despite having a similar provision like in India, our courts have decided to refer and adopt the rationale given by the minority decision in Mian Bashir. Okay, now let's have a look at what the Supreme Court had decided. So, in deciding whether a particular legislation is constitutional or otherwise, our courts have decided to adopt this approach, which is to look into that particular provision and see what would be the direct and inevitable effect of the said law or legislation. So what is the direct and inevitable effect? Now, if the direct and inevitable effect of such law would render certain fundamental rights to be ineffective or illusory, therefore that particular provision is unconstitutional. So it's very basic, very straightforward. Now, I have no qualms with regard to this particular approach. In fact, this principle can be applied in any other challenges to any laws that we feel would be infringed on fundamental liberties. So the test is that the moment any piece of legislation or amendment to the law that has the effect of rendering our fundamental liberties to be ineffective or illusory, it can be considered to be unconstitutional. Now that is the principle. So the issue is whether or not this principle was rightly applied in this particular context. That is the issue that we'll be discussing later on. Now, it's also important to note that there is a distinction between freedom of association and the right to be a member of parliament or state legislative assembly. Now, these two are not the same. If you look in our federal constitution, the rights, among the rights that are guaranteed is the right to form an association, to be a member of a particular association. So that freedom of association is enshrined in Article 10 of our federal constitution. There is no doubt about that, subject to Parliament making certain laws to restrict that right, subject to the conditions being satisfied. Now, to be a member of Parliament, or to be a member of the State Legislative Assembly, that does not equate, it is not a right. In other words, it is not a fundamental right guaranteed under the Federal Constitution. It is not part of Article 10. However, the Supreme Court in the case of Nordin Salleh had interpreted saying that the restriction or the net effect of having that amendment, in the moment you jump from Party A to Party B, you lose your qualification, you lose your right to be a member of Parliament or a member of the State Legislative Assembly. Therefore, it renders your right to join another political party to be ineffective and illusory. You see how the Supreme Court decided, they said, they tried to link the right or the qualification or disqualification of being a member of the State Legislative, they tried to connect it with the right to be a member of a particular political party. So the two are distinct, the two are different, but somehow the Supreme Court in that particular case they decided they form one and the same because it renders your right. If I want to join political party B, but I cannot do that because the net effect is that I will lose my seat in Parliament or in the State Legislative Assembly. Therefore, it renders my right to join political party B to be ineffective and illusory. So essentially, that is the rationale given by the Supreme Court in Nordin Salleh. Now, that issue was also similarly discussed in Mian Bashir by the majority decision. They discussed about the same point. I mean, all points that were argued was also discussed and argued by the majority decision in Mian Bashir. But interestingly, in Mian Bashir, the majority decision took a different approach. Okay, now can we move on to the next slide? Yes. Now, if you look here, this is what the acting CJ in Mian Bashir had discussed. And given the reason as to why there is a need to have this kind of legislation. The acting CJ in Mian Bashir was commenting about the political climate in India at that point in time, which is not much different from what we have experienced post-2018. There is a flurry of members of parliament or even state legislature jumping from one side to another. So it's becoming very rampant in India at that point in time. So because of that, this is what the acting CJ had decided. He's saying that, of course, if you want to change your allegiance or alliance for principal reason, there is nothing wrong with that. For example, if you disagree with your political party because of certain legal issues and you decided you want to support the opposition, fair enough, you can switch your allegiance based on principle. But I think what we have witnessed lately is that the change of parties or the change of allegiance was not made on the best of ideals. I mean, the motives are questionable, whether or not they are doing it for the right reason or whether they're doing it in the interest of the rakyat. So because of that, the acting CJ Myanmar decided we need to have this kind of law to curb this kind of practice. And the Supreme Court in Nordin Salleh at that point in time made the distinction saying that we do not have that problem in Malaysia. There is no evidence to suggest that we have the same problem that India was facing at that point in time. Well, perhaps back then, of course, the rampancy of jumping or switching allegiance is not that prevalent. But I think post 2018, we had witnessed, right, from the moment the election results were known, horse tradings were made, and we witnessed the collapse of several governments from Pakatan Harapan to Perikatan National, and who knows what's going to be the next coalition. So we witnessed because of what has happened, it had led to political instability. And I think that is not in the best interest of the public. That is not what democracy is all about, because if you want to change your allegiance because of principle, well and good. But if you're doing it for political expediency, for your own personal interest, I think at the end of the day, the public is the one who will suffer the most. So given that background, I suspect, and in fact, I would believe, I would submit that the Supreme Court, if they had this information or they could see what had happened in Malaysia, they may have come to a different decision. They may have adopted the majority decision in Myanmar and upheld the constitutionality of the amendment in that particular Kelantan constitution. Okay. Now, in Myanmar as well, I was mentioning that the majority decision had discussed about the right to be a member of the State Legislative Assembly or Parliament, and the right to be a member of a particular political party. Now, I'm sorry, I do not have that particular slide, but I think an excerpt of the case of Myanmar, the majority decision held that the impugned section in the amendment to the constitution that restricts or disqualifies a certain member from being a member the moment he jumps a political party does not prevent the petitioner from withdrawing his membership of a political party, but it only lays down that he shall not continue as a legislator. So it means that just because you want to change your allegiance, you want to join a different political party, there is nothing stopping you. The only thing that would happen is that there will be some consequences, and that consequences does not necessarily mean that your right to join a different association or political party has been restricted. I think it is also common sense and common knowledge that if you join a certain political party, you may have to forego or let go your membership of a certain groups or certain association. So that kind of practice is not something which is unusual. So the fact that you believe that I no longer wish to be with political party A, but I now want to be a member of political party B, having this kind of anti-hopping law or recall procedure, it does not restrict your right. You still can join. It doesn't stop you from doing so. But bear in mind, by joining it, there will definitely be some consequences. And that does not render your right to be ineffective or illusory. I think that is where the Supreme Court took a different interpretation of that particular scenario. Now, there is also, I'm sure, I mean, like in the morning sessions, there had been discussion about whether or not we should have it automatically disqualification or whether we should have a recall procedure. I think Chin Huat would definitely going to be touched on that, the merits of having a recall procedure. I think one of the reasons why I take the view that Nordin Salleh could be distinguished is that because because the amendment that was imposed or made in the Kelantan Constitution, it renders your membership or renders your seat to be vacated automatically. Now, but if you have a different procedure, that it doesn't render you to lose your seat, but it opens up to be challenged through a recall process. Perhaps it is more palatable. I think Chin Huat would have to go into more detail on that point. So these are the few things that I had looked into Nordin Salleh, and I find that the decision of the Supreme Court can be distinguished and can be revisited. Now, I mentioned earlier on that there is another decision, the case of Abdul Karim. In that case, a similar provision was introduced into the Sabah Constitution, whereby a member of the state legislature will lose his seat the moment he joins a different political party. So there was a challenge made and there was a leave application filed to the Supreme Court, but the leave was not granted. Now, interestingly, in the case of Abdul Karim, the Supreme Court, of course, it was just only a one judge sitting, as opposed to Nordin Salleh, which is a 5-man bench. In the case of Abdul Karim, the Supreme Court held that the state has the right to determine the qualification and disqualification of its member. Okay, so essentially what the case of Abdul Karim had decided is that by referring to item 4 in the list 2, the state list under the 9th schedule, that every state has the right to determine the qualification or disqualification of its member. Of course, as long as it doesn't offend the federal constitution or it doesn't go against the 8th schedule of the federal constitution. That is the mandatory provision. So you can have additional factors to be taken into consideration if you want to disqualify a person from being a member of the state legislative assembly. An example is that when it comes to absenteeism. Now, if you look in the 8th schedule, there is nothing said about absenteeism. I mean, if you fail to attend the sitting more than a certain number of times consecutively, you will lose your membership. That is not expressly spelled out in the 8th schedule. But if you look at the state constitution, most of them have that particular, or they have enacted that particular rule, saying that if you fail to attend or the sitting after a certain number of times, you can lose your membership of the state legislative assembly. Now, that is an example or illustration to show that the state has the power to determine and to decide as to when one can be disqualified over and above what has been mandatorily prescribed by the Constitution. So that is the approach that the Supreme Court in Abdul Karim said. They are entitled to do so. So the challenge that was made in the case of Abdul Karim was decided by the Supreme Court to be frivolous. So that was in 1988. And that case was never referred to or discussed in Nordin Salleh, which I find it a bit bizarre. I can't really comment why. Maybe it was an oversight by the parties who argued the matter. But it would be an interesting, it would be even more interesting case had the Supreme Court in Nordin Salleh had the benefit or opportunity to look at the case of Abdul Karim, scrutinize it, assess it, and give their own reasoning why they do not wish to follow that particular decision, or whether that case can be distinguished. Now, because of these two different decisions, I am of the view that the state still has the power to make the necessary laws in order to introduce such legislation. Okay, so it is not necessary that you have to go to the federal level. That means you adopt what has been introduced by the federal. But I believe, based on the reasonings that I read in the case of Abdul Karim, and after looking at the case of Nordin Salleh, I want a firm view that yes, the state has the power to do so. As to has the process and mechanism, that's a different issue. But in terms of the competency yes, they have the power to do so. Now, in terms of consistency, whether or not it is inconsistent with the federal constitution, I am taking the position that it does not offend Article 10. It doesn't come within that because it still comes within the certain provisions which states are allowed to enact and to introduce in their own constitution. Okay, so this is what I would like to share with the audience today about the case of Nordin Salleh. And of course, let's not forget, we have the case of Bukhari that I mentioned just now. So while we talk about Nordin Salleh, which is often quoted and debated in Parliament, outside Parliament, there's also another lesser known case that has taken a totally different position, had more or less decided that it is constitutional to have such amendment in the state constitution. So given this premise, it is open to the state, depending on the political will of the state government, whether or not they would like to introduce this particular amendment to their own constitution. And in Penang, I remember correctly, in Penang, there was a challenge, and I think the case was referred to. I'm not quite sure what's the outcome of the case, but there was a challenge made against the proposed amendment to the state constitution. And of course, the matter was referred to because, and one of the points that the High Court judge in that case highlighted that there is these two conflicting decisions which need to be resolved by the federal court. Okay, I think that's about it. If there is any further question, feel free to ask during the Q&A session. And without further ado, I would now like to pass back the mic to our beloved and lovely MC, Ms. Maha.
Thank you so much, Amer. While we have you there at the podium, if I could just take one follow-up question based on what you submitted in your views. So I think where we stand at this moment is at the position of lawmaking or policy making. So our lawmakers are faced with the necessity of otherwise to consider needing to make amendments to Article 10, largely in response to Nordin Salleh. So Nordin Salleh, as it stands, is binding law. Would you agree with that?
Of course, I mean, as it is, Nordin Salleh is the valid law at the moment.
Yes.
Nobody's saying that it is not the law.
And because of that, and because one of the primary considerations for lawmakers will the amendments that we propose to the Constitution withstand judicial scrutiny? And in light of the fact that Nordin Salleh remains binding, in your view, do you feel that it is incumbent upon lawmakers to consider amendments to Article 10? Okay. Or do you believe that given the case that you've cited, Abdul Karim, or otherwise, or because of the questions you've raised in relation to the correctness or otherwise of Nordin Salleh's decision, do you believe that there is enough in place for lawmakers to ignore the necessity of amending Article 10?
Interesting question, Maha, but I think this is a question which really needs to be looked into from various angles, not solely from the legal perspective, but it also has to be looked at from the practical perspective as well. Now, if we're going to make introduce certain laws, I think we need to ensure that whatever legal issues that may crop up has to be addressed. So even though I'm taking the position that there is enough provision in the existing laws to enable the state to introduce this anti-hopping law in whatever form, be it a recall procedure or direct disqualification, but to avoid the necessity to have that particular provision being challenged. And because of that, we still need to address the concerns raised by the Supreme Court in Nordin Salleh, which is the Article 10. And actually, so this is one of the issues that parliamentarians must debate intellectually in Parliament as to whether or not such anti-hopping law actually infringes on the freedom of association, which was discussed in the majority decision in Mian Bashir. So of course, the Supreme Court take a different position. So we need to discuss that. And if we can avoid the need to have this issue being tested again in court, let's take this opportunity. So to answer that question, from the practical point of view, I think it is safe to amend Article 10 so that we can cater the concern raised by Nordin Salleh. And at the same time, of course, we need to look into the 8th schedule because that talks about the qualification and disqualification of members of parliament as well as state legislative assembly. So these are the two provisions in the constitution that has to be addressed, so in order to avoid any potential legal challenge in future.
Thank you very much, Amer. Thank you. Next, we have Huat. And on the back of Amer's explanation of the legal position, Huat will now summarize the pros and cons from the political perspective between imposing federally enacted anti-hopping laws on every state in Malaysia versus enabling or empowering each state to design and enact its own local anti-hopping laws. Over to you, Huat.
Thank you, Maha. And thanks to the bar and Rase for having me. And it's always a joy to listen to Amer enlightening view on our constitutions. Now, I'm going to continue from what Amer discussed just now. This is also from the 1992 verdict, and this is the part that actually mentioned the 8th schedule. We have to discuss this because to our knowledge, that the parliamentary committee that is studying the anti-hopping law is looking into that. And so this part basically say the Kelantan anti-hopping law, which is in its state constitution, does impose a restrictions on the exercise by members of the legislature of their fundamental right of association guaranteed by Article 10, (1)(c) of the Federal Constitution, and that such restriction is not only protected by Article 10, (1)(c) of the Federal Constitution, but clearly does not fall within any of the grounds for disqualification specified under Section 6, (1) of Part 1 of the 8th schedule of the Federal Constitutions. Now, for those who are not familiar with this part of our Constitution, the 8th schedule spell out what should be included in the state constitutions. And the Part 1 is the essential provisions, meaning that if the state's constitution does not contain this part, or they have something contradictory to what is provided in the 8th schedule, the parliament can even pass a law to impose that on the state constitution. So this is the part that we have to look at. Now, if we go by the general view on how far does this tie it down, it seems to me that the states cannot have their own anti-hopping law in the traditional sense. What I mean by in the traditional sense, by which I mean automatic seat vacation, meaning by the operation of law. So you have that situation and the state cannot have it, as we have discussed just now. So should the states be allowed to have AHL? Yes, of course, because this is actually, in fact, just like the case of India, anti-hopping law started in Malaysia at the state level before proceeding to the federal level. And that is something I want to underline, because that if we believe in uniformity of law, then all the states, including Penang in the latest case, have they have acted in the way they should not. But this is, if you look at the situations we are dealing with, then it makes perfect sense for the states to take their initiative. So the next question then is that, must the federations and all 13 states have the same AHL? I put this question here because it's appeared to me there is this understanding that if you do not touch the 8th schedule, then we will not be able to overcome it unless we go straight to Article 10. So I'm just going to, okay, so if we want to put some things that enable the Article 10, this could possibly be something like this. It's just an attempt by my colleague Chang Si and I. We basically suggest that if you should introduce anything, it should be very specific and be so specific that it's about the change of their political party affiliations after elections for members of parliament and members of the state legislative assembly, and to be imposed by this constitution meaning the federal constitutions and the state constitution respectively. Now, I'm not at all saying this is the best way to go through that. I'm saying that if this is where we are going, we want to touch on Article 10, that could be one direction to pursue. Be very, very specific, and this is different from what you have seen from the late draft in that came out on the 6th of, after the 6th of April. Now, what about if you want to make an amendment to the 8th schedule? We think that you can actually have it in an open way. So this is what we attempt to propose. The Legislative Assembly shall, by provision of this Constitution and or law, impose restriction on the change of political party affiliation of a member of the Legislative Assembly after election, such that a person shall, in accordance with the provisions of this Constitution and all state law, so provides, cease to be a member of the Legislative Assembly, the seats shall become vacant. So we are proposing some things as generic as this, that then the states would have to have something, some form of AHL, but we are not tying it down to say it has to be a particular form. Now, why this is important? Because we know, to our knowledge, that the alternative to that is something state imposing. So you're going to have a replica of the federal AHL, where you have somewhere between a new article somewhere between Article 48 and Article 53 that spell out what constitutes party hopping and how, what's the consequence of party hopping. So you would have a replica of the federal AHL in the 8th schedule. And then the safeguard that has been proposed is that the entire anti-hopping law would not come in force immediately, but rather the dates of commandments can happen later, and in fact, they can have different dates. Why? The idea is to secure the consent of the states. Now, we do not think that this is actually sufficient, because what eventually say is that the states are left with a proposal and their choice is yes or no, or maybe how long are you going to continue to say no? They do not actually allow the state to have the option. And this is a part that we want to underline, that why does it have to be so restrictive? As I mentioned, both in Malaysia and in India, anti-hopping laws were state initiatives. Again, you find, even on talking about recall, you find that in countries like Canada, they have it at the provincial level before getting, until now they do not have it at the federal level. So why do we need to tie it down, impose on this? But what's really the reason that why shouldn't be? Because we have to look at the options. Now, on the left-hand side is the mechanism. When we talk about anti-hopping law, or the traditional anti-hopping law, if you like, we are talking about automatic seat vacation, meaning by operations of law. The moment that you meet the criteria, one of the criteria in the law, then the seat would be vacated. And the alternative to that, one alternative to that, let's put it this way, would be recall, or if you like, voters-initiated seat vacation. So, and there is not a single form of recall. To our little knowledge, my colleague Changsi and I, there are at least 4 models of recall law in the world. And the one proposed by Bresset and Y.B. Azalina is a fusion of 2, the British and the British Columbian model. So we're talking about the 5th type. So recall itself allows a lot of options how you want to do it. Now, what's the difference between the two options is that if you are looking at automatic seat vacation, the idea you have when we talk about political accountability is that the representatives should be accountable to their parties because it's a party who nominates them. Underlying assumption of this is the parties would be accountable to the voters. What if the party is actually not with the voters, but the lawmaker is with the voters? So ultimately, we are looking at the assumptions that we have in our mind. What do you really want? Now, if you go back to recall, and I want to respond a bit to the earlier discussion, to me, it's not so much about good guy, bad guys, but it's really about, not about direct democracy per se, but it's about who do you empower to decide who should be accountable to. So that's what we mean by recall is eventually you do not make decisions for the voters, you let the voters to make their decisions. Now, the options on the left in terms of mechanism is closely tied back to the options at the right, which is about the definitions of party hopping. Now, party hopping is a common word that we use. I use it as a shorthand. To be more accurate, we should say party affiliation change, because that would be a neutral term. And then what are the things that can be covered? We can look at least 5 things. One is party to party, as discussed in the morning. Second is from parties to become independents. Now, these two are straightforward in what YB Gobin has described as clear-cut cases. But we have at least three other types as not so clear-cut. One is about expulsion. Why? Thomas has taken at length to explain that if you exclude that, then the anti-hopping law becomes toothless. But to include that, you give the power, tremendous power to the party leaders, so that if they want, they may abuse it to eliminate their intra-party rivals. By sacking their rivals from the party, they can indirectly sack their rivals from the legislature. And if this happened in the last 2 years of the House, whether the Parliament, the State Assembly, then the sacked lawmakers would not even have a chance to contest in the by-election. Now, related to that is coalition hopping. So it's a question that we pose. Would the Malaysian public be satisfied that if we have an anti-hopping law that would, if you go back to the Sheraton move, punish not Bersatu because it's coalition hopping, but the 6 ex-Bersatu MPs, starting with Tun Dr. Mahathir, who left the party. Would the public be satisfactory with this? And the third point is independence to party. That's the objections raised by YB Rallison in the morning. Now, the options here is that if we are going to, in the most straightforward way, in the most ideal situations, we get the draft before 6th of April applied. Then you cover basically almost everything. Almost everything meaning the only part that's left hanging is whether it would cover coalition hopping, depending on how do you define parties. But what if you go back to the minimum positions as put forward by YB Rizwan? YB Rizwan say, we should just stick to the first two, party to party, party to independence, get it passed, the rest, you leave it until next round. And somewhere between that is YB Gobin's position this morning. Now, if we were to have a single set of law, we could end up possibly in 2 extremes or any point between them. The first is that you have a very minimal, almost ineffective set of anti-hopping law, both at the federal and at the state level. Second, on the opposite, you have a very powerful one, but that may come with unintended consequences. So the question we need to ask here is, why must we put all the eggs in one basket? Because we have 13 states. What's the argument to support the decision that whatever is chosen by the federal government should be imposed on all the states? What convinced us that this would be the best decision, rather than allowing the states enough room to explore what they want? Because some states may go for the minimalist, other states may want to go for recall or whatsoever thing. So that's the question. Thank you, Maha.
Thank you very much, Chin Huat. I'm conscious of time, so I'm going to immediately invite Datuk Seri Madius to share with us his views about the most appropriate legislative solution to address party hopping at both national and state level, drawing specifically from the experience of Sabah. And Datuk Madius, first of all, thank you for your patience in staying with us. But I hope that you will also be able to address some of the points, the fundamental points that Chin Huat has addressed, which is the question of uniformity of law, whether that's a necessity in your view. And secondly, the debate between empowering political parties versus empowering voters. So over to you, Datuk Madius. You might be on mute.
Hello.
Hi, Datuk, we can hear you.
Me?
Yes, yes, we can.
Yeah, okay. Yeah, okay. So first of all, thank you for having me. Thank you to the Bar Council. Thank you to Bersih for inviting me. But I must apologize at the outset for not being able to be there with the rest of the panelists, because I have something to do in Sabah and I was listening to the whole presentation in the car. All right. Okay. So I'm going to the point. Basic question of whether the exercise of having the anti-hop law we should impose to the state. Okay. As a member of the committee, I remember putting up the view that there should not be opposition to the state. In other words, hello? Can you hear me?
Yes, yes, Datuk, we can still hear you, yes.
Okay, all right. So that whatever amendment is going to make is only to enable the state, the respective state, to have their own anti-hop law. All right. So that's the first position. The second position, I think that you have to remember, to realize, I mean, from the presentation from the first panelist, is that all this on record, the initiative to have anti-hop law is from the state and not from the federal government. In fact, from the experience of Sabah, the federal government went all the way to make sure that there is no anti-hop law. All right. In that, the state government of Sabah, the then PBS, took the initiative to have an anti-hop law by way of amendment to the Sabah State Constitution. Okay, and as soon as it was passed, it was challenged. It was challenged. They went to the court, to the Supreme Court, to say that it is unconstitutional, that it is undemocratic, and that kind of thing. Again, all those inspiration, that initiative to put that is from the federal government. It's from the federal government. All right. So the federal government has not been all this while interested in having an anti-help law. I think we have to recognize, all right? So it's the state government, the very state government, who is the one who is going to have anti-help law, okay? So what we are saying is that this particular exercise of having anti-help law in this country, okay, involving, and now the action is from the federal government, is simply to make sure one, to enable the very state government to have their own anti-help law, and number two, to make sure that the federal constitution does not restrict the state government from having the anti-help law. For example, like the Sabah anti-help law, which has been deemed to have been what we call unconstitutional, and in a way it has been annulled, but it's still very much there. Article 18 of the Sabah State Constitution, Article 18(2) D. Yeah, it is there. You know? It's only need to operate. Okay, it's only need to operate. Okay, and it can operate through amendment to the Article 10 of the Federal Constitution. Okay, you amend Article 10 of the Federal Constitution, and so Article 18(2)D of the Sabah State Constitution will now be what we call it can now operate. Okay, it's now applicable. So as far as Sabah is concerned, I think the minute that we amend Article 10 and put a certain what we call exemption to that personal liberty kind of thing, then we would have an anti-help law in the state. Okay. What is saying is that now this anti-help law that we're going to do, which is, I would say, a bit of a rush job, because we need to do and pass it a certain time, you know, and therefore then we will not be able to come up with a perfect law because of the time constraint. Yeah, but okay, the very state government should be allowed to come up with their own law, you know, whether it's going to be recall or it's going to be purely an anti-help law. I think we should allow for the state to have that. We should allow for the state. Of course, the other things that will come in, those things that relates to commission, laws related to that and things like that. But I think in principle, that should be allowed. You know, that should be allowed. Yeah. But it is very important to remember that I think the attitude, the thinking of both, federal and state, must be the same in that we want an anti-help law in this country. Yeah, I think that's the basic, Clearly, in the case of Sabah, the then Prime Minister Tun Mahathir, he was really totally against it. In 1992, when the Sabah state government make this amendment, yeah, when they made this amendment, they filed a suit. Tun Mustafa, then Deputy Chairman of UMNO Sabah, filed the suit, and this is where I think the Supreme Court made the decision that particular provision is contravened the federal constitution, and therefore then it has been annulled. So this time, everybody wants it. That's I think that's the most important part at the moment. That's the most crucial part. Yeah. And it can be refined as we go along, but. Time is, I think, under the circumstances. For me, as a member of the select committee, I think we will, as much as possible, try to come up with the best law that is applicable. But Obviously, I think at this point, at this stage that we are going, at the rate that we are going, at the national level, I think it will only be what Huat called the conventional anti-hope law. Conventional anti-hope law. When you come to recall, I think there'll be you need that time to refine it. But I think we should make a good start, you know. So yeah, I think that's my view. I think the principle, the basic policy when it comes to anti-hope law, I think that should be that has to look at it. Yeah. At the moment, a lot of the toughest part that we are going through is this dichotomy of whether this is going to be pro voters or pro political party. That's the toughest part at the moment, because there are other issues that that we need to consider, things like expulsion, the issue of expulsion from the party, you know, whether that will constitute as a hopping and that kind of thing. So that is the challenge that we are going through. Of course, there are views. The views we say is that okay, we should disregard that totally, and that it should be qualified. But when you qualify that expulsion again, there's no end to it, you know, it becoming bigger and bigger and become more complicated. So in fact, it should be made. It should be made as simple and and not complicated in the way that Singapore does it and India does it. Yeah. So Maha, that's all I can contribute for now to the discussion. Thank you very much.
Thank you very much, Datuk. I suppose the central question here is really how much are we sacrificing for simplicity, and what are the potential consequences down the line, the long-term consequences, not simply to Parliament, but perhaps even the very fabric of our constitution. And I believe these are the long-term implications and potential implications that perhaps without hindsight, it may be difficult to predict. But what we can say, and I think what a lot of experts have already talked a lot about, is that in addition to anti-hopping laws, in whatever form they may be, there needs to be other laws in place. There needs to be other solutions in place that must be brought in tandem with anti-hopping laws. Some of the good examples that have been talked about thus far, and I think we will be talking about it in the next session, is control over constituency development funds and potentially as well political funding. I wonder, Datuk Sri, whether you have any views on this, and whether in your understanding, whether this committee will address these issues, the necessity to look into constituency development funds and perhaps even larger issues relating to political funding.
Well, this particular select committee is very focused on the anti-hope law and, you know, and related to it, no? But constituency funding, it should be something else. From, I mean, on hindsight, you know, out of the MOU that we have signed, and now that we have our own, that we in opposition is given a fund, on hindsight, we should have demanded for an act of parliament to govern political fund. I mean, for constituency development fund, there should be an act of parliament. But whether or not this should be something that we want to discuss in the select committee, I think no. I think this is a little bit too much for us now. I'm on record. There is only 2 more meetings to go, which is on the 12th and then on the 23rd, right? Okay, so but I think really with anti-hope law in place in this country, that should catalyze to politics that is more and more professional. We should then context on the strength of policy offering that they are giving to the people and things like that, And therefore, then constituency development funds should be given to all elected representatives, respective of their political parties, opposition or government, things like that. In other words, we should not compete based on our strength of addressing welfare issues, but rather we should be competing based on the strength of our policy offering, our lawmaking proposition, and things like that. In other words, politics become more and more professional. More we should professionalize politics as we go along. That I think that is the aim and product that we are looking at. Yeah, but for now, just this anti-hope law alone in itself is already very, very complicated. For example, okay, if we say that the process of election is a contract between the voters and the candidate. Okay. Some of the views in the select committee says that the candidate is represented by the logo. Okay, by the logo, and therefore then logo is important, and things like that. But then again, that is between a logo and the voters, But how about an opposition party? I mean, how about the independent party, who just pick up any logo, things like that. It could be a kunci, it could be ayam. So can the ayam represent that candidate, that kind of thing. So it's becoming bigger and bigger. That is why we say it's better to just have something now, make it as simple as possible. For now, it might not cover all the issues yet, but with the view that it should be addressed as we go along. But if you look at Singapore, I think it has served Singapore very well, that particular provision, and so is India. I think. So it's just that here in Malaysia, there are too many political parties, there are too many coalitions and things like that, consider. So yeah.
Thank you. Thank you so much, Dr. Seri. I would like to open up to the floor for questions, but before I do, if I could just pose that same question to both Amer as well as Chin Huat, but Chin Huat first. So in your view, are there other legal measures that should be adopted, either in addition to anti-hopping laws in whatever form, or perhaps instead of anti-hopping laws?
Yes, certainly I think that we need to have a package deal, and I think Dr. Seri and his colleague can actually consider to add in their recommendations, not going into details of what should be done, but they should appear in the report and say they are views, and these are not by a tiny minority, that we need a package deal on this, that either this committee or other committees can be set up to pursue those agenda. Now, one of the things I would like to touch, and maybe people have overlooked, is the size of our cabinet or our government front bench. Now, why this is important, people like to look at India anti-hopping law and to cover this, but you should not forget about their latest amendment, which is going after the people who wants to be minister after crossing over. So India set a limit of 15% of the Parliament House, the lower house. And the same thing you would find in UK. UK has 650 MPs, and the number of salary positions for minister is capped at 95. Now we have that in our states. A state can have a number of exco or state minister, including the chief minister, from 5 to 11. It's not tied to the size of our legislature. So it makes no sense for police, because 60% of the Aduns are state minister, exco member. But it did cap the number for larger states like Perak, Johor, and Selangor. So keep it at 11, but we do not have anything at the federal level. So I propose that this is something the community can definitely put in because it's a constitutional amendment. You can actually cap the number. And we can be generous. Instead of 15%, let's go for 25%. That's 56 MP. We can even go for, say, either 55 or 56 or 25% in anticipations of future expansions of the House. The other thing we should look into is to prohibit MPs from holding salary office from either statutory body, government agencies, or government-linked companies. And this can be put into Article 48 on disqualification of MPs. Currently, it covers office of profit, but it doesn't include GLC and so on. So we need to put that in. And by removing all this pull factor, you would have less thing to induce opposition MPs to jump over. So there are a lot of things I would not suggest Malaysia to emulate from India's anti-hopping law because it's too stringent to me. But on this part, in curving the offer, we can really learn from India. Thank you.
Thanks. I'm in agreement with Chin Huat's position. In order to address and appreciate the issue, at the moment, the anti-hopping law is merely addressing the symptoms. We're seeing that MPs are jumping from one side to the other. So we're trying to address that issue. But I think in order to really curb this issue, we need to go to the fundamentals. What is the root cause? I think the root cause could be for various reasons. It could be the lack of funding in order to serve your constituency. I think that's why one of the issues that in order to address or to deter people from switching allegiance. And of course, limiting the number of ministership. Because if your motivation, the root cause is because of, I want to be a minister or deputy minister. So by addressing that issue, you would deter people from switching allegiance. So while anti-hopping law is a step in the right direction, but I think that is not the be all and end all. It's not going to prevent everything until and unless we appreciate what are all the root causes. What caused person to switch their allegiance? I mean, and in some cases, it's because of principle. You no longer believe in the ideals that your political party hold. Fair enough. But in some of the cases, it's purely motivated by personal interest. And I think we need to address that. And to deter that, we can look at the various other amendments or introducing other various laws. So it is not only limited to anti-hopping law.
Thank you to both Chin Huat and Amer. And I will just paraphrase Chin Huat. He's raised this point before. I think one of the core root causes is the fact that politics in Malaysia is a zero-sum game. And we don't incentivize the losing team. So I think that is a perspective that we seriously need to change. So are there any questions from the audience? Yes.
Hello. Hello, can you hear me?
Hello.
Hello. Yes, this question is for Mr. Amer. Now, you mentioned about the Nordin Salleh case, right? Which is a state law, isn't it? Now, there's an article in the Constitution, and this is a bit of a legal question. Article 75 of the Federal Constitution is about the consistency of state law and federal law, right? So state laws must conform to federal law, isn't it? Because if the state law is inconsistent with the federal law, then the state law will not be valid. This is, I think, in the Article 75. So, Mr. Amir, this relates to the issue. My question is whether the AHL state laws must conform to federal law. Must it be uniform or must it be valid in accordance with federal law if there's a federal law on anti-hopping?
Thank you. Amer, maybe I'll take the question from YB Teresa as well, and then we can take both questions together.
Yeah, thank you. Actually, there are lots of issues that laws and issues that need to be resolved. And also they are related to why MPs choose to hope to other parties. If you all remember that in last GE, when first time when the traditional opposition parties, like DAP, PKR, we became government. If you look at the opposition side, more than half of them, they were the former cabinet ministers. Okay, so do you know how do they feel suddenly that and they have been, some of them have been cabinet ministers for many terms actually, even since day one when I came into parliament. So you might want to consider to cap the terms of cabinet ministers and so on. There are a series of things that need to we can discuss. But if we are looking at general election, could happen after the end of the MOU, that means 31st July. Now I think the members of the select committee, like Madius, Gobin Singh, and all that, they're cracking their head how to come up with something very simple, but is enough to be to deter MPs from to do party hopping. The less issue that you bring up will be better, right, Madius? It will be better. Otherwise, they will
exactly.
Yes,
exactly. That's the point. Time is a constraint. Time is the essence. Yeah.
All right, thank you very much for that comment, YB Teresa. So Amer, are you happy to take the question from the audience?
As a matter of principle, federal constitution is always the supreme law of the land. I mean, there's no argument about that. And any law that is inconsistent with the constitution will be unconstitutional to that extent that it is inconsistent with the federal constitution. So there is no doubt about that. Now, there are certain things that parliament can legislate and there are certain things that state can legislate. That's why we have the federal list and we have the state list and we also have the concurrent list, whereby both parties, federal and state, can legislate, have their own respective laws or enactments. Now, when it comes to this anti-hopping law, as you can see, the issue is not much. The issue, even in Nordin Salleh, it is not whether or not they are not competent to legislate, to enact their own laws. That's not the issue before Nordin Salleh. The issue is that such amendment infringes upon the fundamental liberties.
Yep.
Okay? So it infringes the fundamental liberties under Article 10. Now, in the case of Abdul Karim, which I mentioned earlier on, the Supreme Court did mention, by making reference to item 7 of the list, and saying that, look, under the machinery of the state government, they have the power to enact laws in order to determine the qualification or disqualification, as long as it doesn't contravene the mandatory provision in the federal constitution. So this is a very fine approach that you need to look. You can amend, you can introduce certain laws, but whatever laws that you want to introduce at the state level must not offend, contravene the mandatory provisions in the federal constitution. Okay, so at the moment, the obstacle that based on Nordin Salleh, they said that because the moment you try to introduce anti-hopping law, you will trigger the infringement under Article 10. But I have a different view, because I said being a member of a political party, freedom association, is not necessarily the same as being a member of parliament or member of state legislative assembly. Two different things altogether. But I mean, to answer your question, yes, you can. I still take the position, the legal position, that at the state level, you can introduce, have your own anti-hopping law, but you must ensure that it doesn't offend Article, the 8th schedule. That's very clear. As long as all those that have been set out in 8th schedule are there, you do not undermine 8th schedule, you're entitled to do so. And the example that I gave earlier on is the absenteeism for not attending the state sitting after. So that is provided in the federal constitution, but state constitutions have included in regulations saying that you can be disqualified if you fail to attend sittings after a certain number of times consecutively. So that is an example that you can disqualify. So let's adopt that approach and introduce it a different scenario. For example, like party hopping. So I hope that answers the question. It is not directly contravening the federal constitution. It's just that at the moment we still have to deal with the issue of Article 10. which I take a different position. But yes, we have to acknowledge Nordin Salleh, it is there staring at us. So that's why I think the select committee are also looking into amending Article 10, apart from looking into its schedule, for example.
Thanks. I would like to, I'm of the opinion that the state can actually have its own anti-hopping mechanism if it's not automatic, because then it would not constitute a direct restriction to freedom of association. In other words, if the states want to have recall, they can try, because there's not an existing precedent, a judgment standing in their way. But if you want to have a traditional anti-hopping law, automatic seat vacation, then of course you need to bypass that. And if the parliamentary committee wants to help the states, especially Penang, which still has a traditional anti-hopping law, then you can help by enabling them, but not by imposing them. So going back to the questions and say we should ask less if you want something to show to the voters. My answer is this: it's not that we ask too much, but we ask too late. Because when PH was in power, we were never encouraged to ask for too many things, because we just come into power. How do you expect us to change things over 60 years? So when would be the right time to ask? I would say now, but not necessary. You have to give it in this federal bill, because some of the things that we talk about, for example, to put it as a ground of disqualifications for holding GLC posts for lawmakers, you can have it at the state level. And if someone wants to challenge it, let them to bring it to court. What we are talking about here is to set the agenda forward. So I do not think that we need to close the discussions to narrow it down so restrictively that we can only discuss item A or B. We can actually explore and then come back to say what would be realistic to achieve. But if the committee main concern is to have less trouble, then I would really suggest don't impose it on all the states. Do what you can by enabling them. Don't ask for trouble by imposing the same. Because if you do so, then you'll be asking, you'll be courting challenges and so on. The same way, don't try to regulate what the MP can say or votes, whether it's on confidence or supply, because the same thing, you're probably going to invite another challenge of constitutionality. Can I just say one thing? Why must we resist these temptations of legal unity, that we should have a uniform law for everyone? Because none of us here would know what is the best for this changing world out there. So if you're going to impose one set of law, you impose on 13 states. Let's say it works on 12 states, and one of the states does not work out. What happened? You need to go back to the parliament, get a 2/3 majority to free that state. Why do we want to dig ourselves into troubles? Thank you.
If I can add, sorry, Mahat. I think Mr. Huat raised an interesting point about the automatic disqualification, and in order to get around the issue raised in Nordin Salleh vis-a-vis Article 10, I think that's a valid point. Because if we remember earlier on, I mentioned about this direct and inevitable effect of a particular amendment. So if the direct and inevitable effect is to render your right to be illusory, then it becomes unconstitutional. So having an automatic disqualification at the state level would caught by the ratio in Nordin Salleh. But if you have a recall procedure, you are not automatically disqualified. It's just that it triggers an option whether or not the voters would like to still have you as the elected representative, or you could be challenged. And that person who had exercised his right under Article 10 to join a different political party can still defend and maintain his seat. So if the threshold is not met, he doesn't lose anything. So I think that will overcome the ratio in Nordin Salleh in order to avoid the legal argument vis-a-vis Article 10.
Both, and also thank you to Datuk Seri. So we have about 15 minutes more. Are there any other questions from the floor? Yes, Chang.
Yeah, I think from all the three speakers, I can see that we are agreeable that the state can actually have their own mechanism, right, in terms of the legal point of view, and also from Huat saying that, you know, we should not have everything into one basket and not legal uniformity. But the reason why we have this conversation today is because of the proposed amendment to Article 10, right, on the restrictions and the exception. So how do we actually deal with it? Well, I mean, what is the reason why we have this conversation? Is it because the government's bill actually purported to have a uniformity, or what? You know, what are we preempting actually? Yeah.
Thank you, Charing. That's a very good question. What are we preempting? And I wonder whether I could first address this question to Datuk Seri Madius, whether he can to that.
Okay.
Are you able, Datuk Seri, insight into what the proposed amendment to Article 10 might look like?
Okay. Amendment to Article 10 has its roots on the two experiences of Kelantan and Sabah, right? We both have an anti-hope law, but it was rendered to be void, null and void, simply because of Article 10. Okay, so therefore, then there's a need to have some kind of what we call exemption or things like that of Article 10. You know, now the challenge now is that how would it look like? Because from the experience of the select committee, it's becoming bigger and bigger. You know, because there are various feelings of people. It should be this, it should be that, and things like that. You know, so. But how do we come out of that? You know, how do we make sure, for instance, like, okay, if you look at the Constitution of Sabah, Article 18, 2D, you know, it's very clear there. You know, it's very simple. It's just like the Singapore anti-hope law. It's very simple, you know. But because you want to have some exemption and things like that, then it become bigger and bigger, and it become, I would say, becoming very complicated, you know, things like the question of expulsion, the question of independent, and things like that. So that how it looks like is still, that's the one that we are grappling with now, actually.
Thank you, Madius. And perhaps I don't know if this is one solution to answering your question, Chow Ying, but I wonder if we could put up Huat's slides again, if that's possible, and if we could move to the slide that was proposed, where he has proposed his version of an amendment to Article 10. And if I could then seek the opinions of both Amer first, and also perhaps YB Madius if he has any comments on what it looks like. So we'll try to get that up in a minute. In the meantime, I will just share a comment that we received, I believe, on Facebook. This is from Louis Van Burl. He says that we should not complicate the constitutional amendment. YB Govind's suggestion is better, and we should keep it simple to the first two categories identified by Huat. Then later we can talk about recall, maximum cabinet members, GLCs, etc. So while we wait for the slides to come up, I wonder if there are any other further questions from the floor. No? In that case, Amer, because we were talking about, really, I think perhaps we should explain to those listening who perhaps don't have an understanding of constitutional law, what is the danger or the risk of Parliament enacting laws in relation to amendments to Article 10 or laws, fresh legislation in relation to anti-hopping laws, what is the danger if these amendments are subjected to judicial scrutiny? What could the potential outcome be if this appears, if this goes before the courts?
Okay, first and foremost, Article 10 talks about, among others, is the freedom of association. So right to assemble, right to gather, have groups, association, political parties, so on and so forth. Now that is part and parcel of vibrant democracy. We need to have right to associate like-minded people to share views, political views. Without that, there won't be any functioning democracy. So the only restriction that the legislature had decided or deemed fit, the framework of our constitution deemed fit, are very limited. It only comes within those limited exceptions. So at the moment, if we want to impose or introduce any law or amend any particular existing laws or constitution that goes against Article 10 or that doesn't come within the ambit of the permissible restriction, it becomes unconstitutional because we do not want the fundamental rights to be taken away. Because once it's been taken away, you don't want to get it back. So I think that is a very dangerous, a real threat, to our democracy. So that is why if we want to amend or to include an additional restriction, it has to be well thought, it has to be well considered and by taking into account various issues. Because the last thing we want is to be caught by a situation where we can't undo it in the future. So now, having looked at this is the proposed amendment by Huat with regard to the restrictions, is that I look at it as being something which is enabling rather than imposing certain ways of how things should be done. So it is left to the state to decide as to what would be the best mechanism for them to introduce based on the different political background. Talking about Sabah has a different political background, Perak, Kelantan. Every state, they have their own political dynamics. So to have one set of uniformity law may not suit the need of each respective state. So coming back to your question, so the danger of amending Article 10 by not drafting carefully, it may open to abuse. It may open to restriction of our fundamental liberties. We have seen some, in the past, some acts that have restricted our fundamental right to association, for example, under the Police Act, where if you want to have a gathering more than a certain number of people, you need to get a police permit. This was before the coming into force of the Peaceful Assembly Act. So you can see that if we do not treat this issue carefully, it could enable the legislature to introduce more laws that would in future undermine our freedom of association without us realizing, because at the moment the focus is so much on anti-hopping law and everything. So if we want to introduce any restriction, we need to be very careful about it. And I think if we still can work with minimal amendment, but working amendment, then let us adopt that particular approach.
Thank you very much, Amer. Datuk Madius, I wonder whether you are able to see the screen and the slide, and if so, whether you have any comments about the proposal to amend Article 10.
Article 10. Oh, this is really quite different from the existing draft that we had in the select committee, because the existing draft is linked to Article 49. Yeah. So, yeah. It looks interesting, I think. Yeah.
Well, perhaps this alternative then can be considered by the
committee.
By the committee as well. Yes, it's a variation to what is proposed. Yes. I will move on. I will move on for now, Datuk Sri, but I will come back to you at the very end for final thoughts. And if you have any comments on this, then please do share them. So any final questions from the floor? In which case, if I could have final comments from the panelists, I will start with Amer, then Chin Huat, and finally Datuk Sri Madius.
Okay, moving forward, if we want to be a mature democracy, I think having this kind of law is inevitable given the recent incidents post 2018 general election. And in order to have political stability, we need to have some sort of law to deal with these issues. But as to what would be the right or the best legislation, I think that is still up to debate. Of course, all of us have the best of intention, but in order to do so, we should not allow any loopholes that would in the future allow a certain group of individuals to use it to their political gain. I think that's the danger that we need to avoid. We should not allow that to happen. Yes, as far as this initiative is concerned, this is something that we have been hoping to exist or to have for quite some time. And the fact that we're having this discourse, having this discussion, I think it is good. And then looking at the participants, I mean, we have quite a sized number of members of the public who are interested in anti-doping law. I think that is a good sign, and we can just hope for the best.
Thank you, Amer. I think that we should be humble on this matter. Party hopping is not something so straightforward that many Malaysians, perhaps including me, 10 years ago, think. Since that, despite our best intention to avoid any unintended consequences, perhaps no one dare to say their proposal would be safe from any of that. Then we should be very careful not to go for one single solution, one size-fits-all solution. Instead, we should seize the chance for experimentation at a subnational level, meaning going back to the traditions of in the 80s, starting from Sabah, and then follow up in Sarawak, in Kelantan, up to Penang, that the states took initiative to explore solutions for the problem they encounter. We must not think that wisdom is a monopoly at Putrajaya, that only when you get to Putrajaya, you would then become so wise that you have all the solutions for the entire country. Thank you.
Datuk Sri Madius, your final thoughts?
Right. It's very interesting that Article 10 is supposed to be the goal of democracy. And it was through democracy that we were able to change the government before in 1985, 1986, right? But when finally the state government took the initiative to impose an law, it is the very same Article 10 that that prevented the anti-corruption which we think that has gone against the very principle of democracy, in that people have given a mandate to a particular government, but the government eventually fall because of switching party membership or things like that. Therefore, then we have to really give a serious thought to Article 10, and therefore Article 10 as to how best we could address that. We have a freedom at the same. We allow for freedom, the personal liberty, and things like that. At the same time, we want to make sure that the people interest is the people mandate is upheld at all time. Yeah. So so that's my final thought. Thank you, Ma'am.
Thank you very much, Datuk Sri. Thank you very much, Datuk Sri, and thanks also to Chin Huat and Amer for joining us today and sharing your wisdom and your expertise with the audience. Thanks, everyone. Thank you.
Thank you. Before we go to the next sessions, I think photo op, YB Madius, can you just stay on the screen for a while? Yeah.
This is the next version.
Yeah.
Wow, all black.
Thomas, sorry. On or without? Oh, all right. On this, I'm fine with the uniform. Thomas,
Oh, one hand. Without mask?
Without mask. All right. Okay. Thank you. Thank you.
Okay, so we are going to the final sessions. This session is going to be like, we spoke about the equal CDF, we spoke about all other reform. So these sessions will actually focus on that.